The U.S. Supreme Court has agreed to hear oral arguments in two cases. Both involve conditioning the receipt of Medicaid on meeting and reporting on a work requirement. The cases are Gresham v. Azar and Philbrick versus Azar, and these trace back to the Trump administration's work requirements in the states of Arkansas and New Hampshire. There have been legal challenges in other states. These are the two issues that the Supreme Court has agreed to listen to in the coming year. Now, recall back in early 2020, the last time we were talking about work requirements in state Medicaid programs was back when the U.S. Court of Appeals for the D.C. Circuit upheld a lower court ruling that struck down the Centers for Medicare and Medicaid Services approval of those Arkansas work requirements. It was a unanimous decision from a panel of judges saying that there was huge losses in healthcare coverage for the people of Arkansas if that work requirement stayed on the books. The appeals court actually said that the Centers for Medicare and Medicaid Services failed to show how a work requirement would actually promote the objectives and the purpose of Medicaid, which they said is to provide medical assistance and access to medical care, not to take it away, which seemed to be the effect of the requirement. The court called that approval of the Arkansas Works program arbitrary and capricious. And they said approval of this work requirement is vacated. We're not going to allow it to proceed. They also commented on the fact that the work requirements violated the Administrative Procedures Act. We're seeing that brought up more and more of how some of these administrative rules coming out of agencies like Department of Health and Human Services, which is where the Centers for Medicare and Medicaid Services is located, going above and beyond what the law allows for determining how some of these policies can be implemented. Well, so health policy and legal experts were actually a little skeptical of why the Supreme Court even agreed to hear these cases in the first place. The National Health Law Program said, "We firmly believe these petitions don't merit review." They did say that they are confident the court will find these work requirements to be illegal, that the action of CMS to approve these in states such as Arkansas and New Hampshire should have never been allowed. It is not likely that the court will hear this argument until after Inauguration Day. Their current calendar is already set, so it's something that would happen later in 2021. Now, of course, Inauguration Day could change a lot. A Biden administration could unwind these work requirement policies, some of the executive orders, some of the rules, and some of the guidance that surrounds it. It's not sure how fast this could happen in a new Biden presidency. There are a number of objectives he has indicated he would try to achieve in the first 100 days. It's not clear if unwinding work requirements in Medicaid is one of them. Unwinding the policy could make the case before the Supreme Court moot, however. It could make it a non-issue. If work requirements go away by executive order or some other agency action, there's nothing for the court to hear. Similarly, a Biden presidency and administration could reject some of those pending work requirement waivers. States like Idaho, Montana, Tennessee have requested permission to add work to their programs. Those haven't been approved, and they too could disappear. There's a lot of information to read about the cases going before the U.S. Supreme Court in 2021. National Health Law Program has been very detailed in keeping web pages both on Gresham versus Azar and Philbrick versus Azar, those two cases we mentioned today. We link to that detailed information in the description below. We also give you the source of our quotes from today.